Okay. All right. Good evening, everyone. Welcome. My name is Adam Carson. I am an associate planner with the Rockland County Department of Planning, and I'm also the executive director of the Rockland Municipal Planning Federation. Welcome to the first half of session 3 of our certification series, the working group discussion for ZBA members. There has been some justified confusion about why there are 2 sessions called session 3. Let me begin by explaining the certification program. Beginning in 1993, Rockland County and Rockland's towns and villages agreed to require planning and zoning board members to take specific training sessions to be provided by the Federation. This requirement is in addition to the New York State mandate of 4 training hours each year. However, the training hours earned at the certification sessions can be applied to the state requirement. Board members in Rockland County are required to take 3 training sessions offered by the Federation. Session 1, overview of the boards, which was offered back in March. Session 2, the update of case law, which was offered last Thursday and will be offered again in the fall. And session 3, working group discussions for planning board and ZBA members. Session 3 used to be held at a single event with board members attending the appropriate breakout session. With our trainings being held virtually, we have divided session 3 into 2 separate nights. Tonight's session is for ZBA members, and the working group discussion for planning board members will be held on Thursday, June 16th. Board members need to take each session once to become certified, and then retake session 2 every other year to be recertified. Before I begin, I'd like to point out that my email address is on the screen. If you are on a board outside of Rockland and need a certificate of attendance, please email a request to me that includes your name, municipality, and board. The Federation maintains attendance records that we share with the towns and villages within Rockland County, so local board members do not need a certificate. Next, if you'd like to ask a question, please type it into the Q&A feature on your screen. I'll be monitoring the Q&A, and I'll relay your questions to Attorney Michaels throughout the session. Please try to keep your questions to general issues. Attorney Michaels may not be in a position to offer legal advice about specific cases or applications if he's not familiar with them. So when the very first zoning ordinance in the United States was created in New York City over 100 years ago, it was viewed as somewhat radical. There were serious doubts that this system of rules that said what could be built and where wasn't a constitutional infringement on individuals' rights. I don't have time, and nor am I qualified to give a lecture on all the legal challenges and developments that came after that point. But I just want to point out that the role of the Zoning Board of Appeals is a critical part of the ultimate constitutionality of zoning. I expect that many of you are aware that a municipality in New York cannot have a zoning ordinance without also having a Zoning Board of Appeals. I think that this speaks to the importance of the ZBA. Its ability to act as a safety valve and help balance the rights of individuals and the needs of the community are a required element of zoning. We are very fortunate to have with us tonight Attorney Dennis Michaels, who will help illuminate the roles, powers, and duties of this essential board. Dennis is a graduate of St. John's University School of Law in Jamaica, New York, and is licensed to practice law in the states of New York and New Jersey, including the United States District Court for the Southern and Northern Districts of New York and the District of New Jersey. In addition to his private law practice in Nyack, Dennis currently holds the positions of Deputy Town Attorney for the town of Orangetown, Assistant Village Attorney for the Village of Haverstraw, and Assistant Village Attorney for the Village of Spring Valley. Dennis was also the Assistant Village Attorney for the Village of Piermont from 1997 through 2017, and enjoyed a year as the village attorney for the Village of New Hempstead in 2016 and 2017. During his 26 years as a municipal attorney, Dennis has served as legal counsel to the Zoning Board of Appeals, Planning Board, and other land use boards, as well as handling a wide variety of other areas of municipal law. Dennis has had a private general civil law practice in Nyack since 1993, which also includes civil and commercial litigation and real estate law. He's a lifelong resident of Spark Hill and is married with 3 children. So with that, I will turn things over to Attorney Dennis Michaels. Thank you very much.
Thank you, Adam. I appreciate those kind words. I'm going to dive right in, just some cautionary requests, I guess. is I know many of you or have applications before you, or some that you're expecting, others that may have recently come before you, and you'd like to hear my advice on those applications. Yeah, maybe I can answer one or two, but I don't want this session to become a legal counsel session where you're asking me about applications that are going before your zoning board of appeals in your village or town. First of all, I have a lot of material that I would like you all to hear before you start getting into the nitty gritty of particular types of applications. So, allow me to go through the material. Adam is going to filter, or rather review, your questions. I can't multitask. I know there's some presenters that are able to present, go through their papers, and also look at the Q&A. I can't do both, but Adam's going to help me out. So if you're wondering why I'm unresponsive to your question, it's because I don't see it. And also Adam is going to help me filter them and pick out questions that are on topic and are not too specific about a particular project application that's going before a board. The other reason that I don't like to give advice about applications that are specific applications for a village or town board is that I may give you the wrong advice. I've been wrong, and I will be wrong again. And that could be disastrous, for you as a member of your ZBA. And also, sometimes I'm right, and maybe your attorney is wrong for your board, and I may embarrass him or her, and I may get an angry call from that attorney tomorrow or another day saying, you made me look really stupid, Dennis. Thanks a lot. So for those two reasons, please avoid asking about specific applications before your ZBA. And that's it. Oh, we're going to spend the overwhelming amount of our time is going to be on area variances, also known as bulk variances, area or bulk variances. The overwhelming majority of your applications will be area or bulk variances. By the way, area and bulk variances are synonymous. They mean the same thing. So we're not going to spend much time on use variances. We'll talk about them a little bit, but because they're very rare, and number two, they're very difficult. They're extremely difficult. So we're not going to be able to cover it within a 2-hour session that's supposed to cover everything a ZBA handles. We will touch on use variances, but my best advice to you on use variances, you're going to need your hands to be held by your legal counsel. Whoever your ZBA attorney is going to need to guide you. They're very difficult, not only from the review standpoint and the applicable law, but the application itself for the applicant is extremely difficult for the applicant. And again, they're very rare. So you're not going to see too many applications for use variances. I would say if you've been on a ZBA for 10 years, maybe you'll see one. Okay. And special use permits and interpretations we'll touch on as well, not because they're hard, because they're very easy and we don't need to spend much time on them. Okay. So let's start with what's the difference between a use variance and an area variance. A use variance, and I'm reading pretty much from the New York State statute. A use variance is the authorization by a ZBA for the use of land for a purpose which is otherwise not allowed or is prohibited by the applicable zoning regulations. So for example, you're in a residential zoning district, only single family detached homes are allowed, and someone is proposing a garage, a gas station. That would be a use variance. You can't have a gas station in a residential zoning district. That's crazy. That would require a use variance. An area or bulk variance, again, they're synonymous, is the authorization by the ZBA for the use of land in a manner which is not allowed by the dimensional or physical requirements of the applicable zoning regulations. So what that basically means is the size of a building or the degree of structures on a site. Some municipalities have something called lot coverage. So how much of the land is covered by impermeable, I think that's a word, driveway, building, structures that cover the lot, that would be lot coverage. That's That's a dimensional regulation, and that would be an area variance if someone needed a variance from lot coverage. Of course, building height, front yard depth, rear yard depth, side yard depth, anything that has to do with the size of a building or a structure is an area or a bulk variance. So those are the differences, and we're going to spend most of our time, if nearly all of it really, on area variances, because that's what you're going to be dealing with the bulk of your applications. Any questions about the difference between an area variance and a use variance? Just the difference between the area and a variance and use variance. Adam, do you see any questions? Because that's pretty easy, but it's okay.
No questions yet.
Okay. Just some preliminary things before we get into area variances. All applications that are before a zoning board of appeals where you're required to vote on, whether it's an interpretation, special use permit, area variance, or use variance, if the zoning board of appeals is going to take formal action on an application, it must be by a public hearing. And you may say, well, what do you mean? And we do everything by public hearing. Well, not necessarily. Understand the difference between what a public meeting is and a public hearing. A public hearing, think of a capital P and a capital H, big P, big H, public hearing. It's a legal formality where certain public notices have to go out, have to be published in the newspaper by state law. There has to be a publication in a newspaper. Also, by local law, state law only requires publication in a newspaper. Abutting property owner notices, that's a creation of local law. Your village or town may require that mailings go to abutting property owners or owners within 500 feet or 300 feet, 250 feet. All depends upon your own local zoning regulations. So your particular village, your particular town code may require abutting property owners or neighbor notices, as we call them. Also signs that are posted on the building or along the property line. So signs on the lawn or in the yard or along the front yard, or some municipalities require signs around the entire lot. Those also are creations of local law. That is not a state law requirement. So just be aware of that. That's when it's a public hearing. And what a public hearing mandates is that the zoning board of appeals, or whatever the land use board is that's required to review an application by public hearing, must allow the public to speak, must allow the public an opportunity to be heard. And you can impose a time limit on speakers as long as it's fair and equitable to everyone. If you're going to make it 3 minutes, it's got to be 3 minutes for everyone. It also has to be reasonable. 30 seconds, there's no black and white line, there's no law on this, but a reviewing court, if there's a lawsuit brought against the ZBA and the chairman announced at the beginning of the meeting that speakers would be limited to 30 seconds, a judge may deem that to be unreasonable. But 3 minutes seems to be the general rule. Again, there is no New York state law that says what the limit must be. Smaller villages with lighter agendas, fewer people coming to the meetings, you might allow 5 minutes or 6 minutes or until the speaker runs out of gas. But for busier municipalities that have a lot of applications, a lot of speakers, I've seen as low as 2 minutes, but I've never seen less than 2 minutes. And also just be fair. If you're going to limit speakers to 2 minutes, and in response to a question that the speaker asked, the applicant spends 2 minutes answering the question, well, is that really fair to attribute that time to the speaker? You just have, it's not a mathematical science. You just have to be reasonable and fair and be equitable to everyone. Here's again, these are all preliminary things now that I think are helpful for ZBA members to know. Once you have an application before you, you should open the public hearing. So you make a motion to open the public hearing. There's a second. Anyone second? Second, open the public hearing. All in favor of opening the public hearing? You can do it in 7 seconds. So now the public hearing is officially open. After you open the public hearing is when you receive testimony, you hear the presentation from the applicant, you reference in the record all of your application submissions from the applicant, also correspondence that you receive from the Rockland County Planning Department sometimes, if it's subject to a GML review, we'll get to that. Everything and anything that the board has received, letters, emails from neighbors, from any referral agencies such as the Palisades Interstate Park Commission, any and all correspondence, reports from your village planner, your town planner, your village engineer, town engineer, your building inspector, all of that should be referenced in the record. You don't have to recite it. You don't have to read it all. Some municipalities do. Again, all depends upon your agenda. If you only have 1 or 2 items on the agenda, go ahead. You can read the whole thing in. But if you have 10 items on your agenda, that's not going to be possible. The important thing is to reference it in the record. We have correspondence from the Rockland County Planning Department addressed to the Zoning Board of Appeals dated April 10, 2022. It's submitted pursuant to New York State General Municipal Law, sections 239 L and M. We'll refer to it as the GML or GML report. And it consists of a general disapproval and 15 comments. It's just a reference to the correspondence in enough detail that it could be clear what you're referencing. Correspondence from the applicant's representative, the applicant's attorney, so on. Who it's from, what letter, the letterhead it's on, the masthead, the letterhead, who signed the letter, the date, and who it's addressed to. You can just reference all your reports and correspondence that way. The same thing goes with sometimes you get emails from concerned neighbors that can be very lengthy. If you don't have to read the whole thing, but reference it in the record. The important thing is that the ZBA members read all of the correspondence and reports and submissions. So just because the clerk or secretary or the legal counsel just references the objecting email from a concerned neighbor, certainly the ZBA member should read it in full. In full. That's obviously important. After you review the application, you've heard all the testimony that you're willing to hear, and you should hear everyone that wishes to speak up to that limit that you restrict. You'll need to close the public hearing. It's critically important that you close the public hearing at the very end before you vote. Now, the reason you do that is because sometimes you'll get letters, emails after the public hearings has been closed, and you cannot consider that email, that correspondence, that letter, that report. If it comes in after the public hearing has been closed, sorry, the ship has sailed. The public hearings have been closed. Your report, your letter, email are not going to be considered by the ZBA. It's very important to have a black and white line of when you're going to stop receiving information, testimony, documentation. It has to end at a certain point because of this. Once you close the public hearing, the good news is you have 62 days if you're a village, 60 days if you're a town. I may get that backwards, but generally you have 2 months. You have 2 months within which to render a decision. You don't have to decide it that night. That's the good news. You close the public hearing, and if it's an easy application and it's not late, you want to make your decision that night, sure, go ahead. You can make it that night, close the public hearing, then right there you can make your decision right on the spot. Or you can wait till the end of the meeting, which a lot of boards do. Either way, it doesn't matter. But the good news is you don't have to make the decision that night. You have 62 or 60 days, again, depending on if it's a village or a town, within which you must make a decision, approve or deny. Now, what happens if the 60 days, the 2 months goes by after you've closed the public hearing? You have not yet made a decision. Well, it's deemed denied by default. It's by New York State law, it's deemed denied. 1 second, sorry. The dog is scratching at the door. So you don't have to worry about a default approval. Like, oh my God, if we don't deny this within 2 months of the closing of the public hearing, it's going to be approved by default. Now, some local laws, some village and town codes have a default approval provision in their local law. It's superseded, it's preempted by New York State law, by New York State village or New York State town law, where for zoning boards of appeals, if you don't take action on an application, you just lays dormant for over 2 months, it's deemed denied. And back to the importance of closing the public hearing. Let's say you close the public hearing, you decide you're not going to make a decision that night. You're going to make it to your next meeting, which might be 2 weeks or a month later. And word gets out on the street about this application, that you guys seem to be favorable to, and there's some objecting neighbors out there who didn't show up to the meeting, or they just found out about it for whatever reason, because they didn't get a notice, because they live, half a mile away. They start sending in emails and submitting reports from their own experts opposing the application and demanding that you deny it. All of this after you close the public hearing. Well, the good news is you should not consider it. Legally, you don't have to, nor should you. You would be highly improper for you to consider any testimony or correspondence or information or reports that you receive after you close the public hearing. Okay, so that's the importance of closing the public hearing, to stop that pipeline of information and correspondence coming in. And it's just a few more preliminary things that I think would be helpful to you to know. Let's see. All right, I think that's it for the preliminary stuff.
Actually, hey, Dennis, there was a
Yeah,
question here. And by the way, please, I'll try to keep an eye on both the chat and the Q&A, but I'm not good at multitasking either. So if you have a question for Dennis, please try to put it in the Q&A. Someone asked, what about a city? I think that was in response to the difference in between towns and villages in the time they have.
All of my experience has been representing towns and villages. We don't have any cities in Rockland County, and I haven't had the pleasure or privilege of representing a city, so I don't have a definitive answer for you. But if I had to guess, I would say it's going to be in that same time frame, 62 or 60 days. Anyway, I hope that answers your question. It's probably the same time frame.
Thank you.
All right, moving. Let's see. All right, let's get into area variances. Now, for area variances, there are 5 considerations. Some people call them criteria or factors. So 5 considerations, criteria, factors. Either one of those words is fine. They all pretty much mean the same thing. But the official terminology used in New York State village or town law are considerations. These are 5 factors that you must consider when reviewing an application for an area or bulk variance. And we'll go through them one by one, and we'll talk about them a bit. Okay. And the critical aspect of these considerations or factors that you should understand is that not all 5 of them do not have to be met in order for you to legally appropriately grant an area variance. So of the 5 considerations, if an application doesn't meet 1 or 2 of them, even 3 of them, there's no black and white line. You can still grant the application. You can still approve of the area variances. Now, obviously, if you don't find favorable for at least, let's say, 3 of the 5, it might be harder for you. Again, you don't have to. There's no law that says of the 5 considerations, you have to find favorable for the application for 3 of the 5, for a majority of the 5 factors, you have to find in favor of the application. There's no law that says that. But let's say you only find favorable on 2 of them, and the other 3, you find that the application doesn't meet those standards set forth in those considerations. Is that appropriate? Sure. You can still grant the area variances, but if it's legally challenged, it might be a little more difficult to defend the decision, unless you have really good, solid foundation for it. Again, it's possible. Okay, so here they are.
Sorry, excuse me, Dennis, before you jump into the five, just, there was a question back about public hearings.
Sure.
So I just wanted to jump back before we got too far down this road. Would it make sense then to continue a hearing instead of closing it if the board doesn't plan to vote at that meeting? That would allow for further information if needed.
That's an excellent question. Absolutely. But if you heard me, and I'm speaking fast because we have a lot to cover. That's a great question. What I said earlier was that when you've heard all the testimony you want to hear or expect to hear or something like that, and all the correspondence, all the reports have come in from your building inspector, village planner, town planner, village or town engineer, so on and so forth, from the highway department, from the DPW, everyone that you want to hear from, you've heard from the fire department, the fire inspector, your drainage consultants, everyone and anyone that you may possibly want to hear from. All the neighbors have been given an opportunity to be heard. When you've reached that point where you're comfortable that you've heard and received everything that you want to hear or receive, then at some point you have to close the public hearing. But if you think that there might be more information coming, or you've asked for more information, of course, you should keep the public hearing open. Okay. And this is critically important. And this was a great question because it reminded me to tell you something. And thank you. Is if you decide to keep the public hearing open, the good news to your clerks and your secretaries is that you do, and for the applicants, is you don't have to republish, you don't have to renotice, you don't have to remail, you don't have to post signs on the property boundaries. If you announce a date and time and place certain that the public hearing is going to be continued to. So for example, the way I do my boards is I make an announcement for all those interested in the application by Jane Doe for 123 Main Street. This public hearing will remain open and the application will be continued and will be reviewed again by the Zoning Board of Appeals on July 14, 2022, 7:00 p.m. here in Village Hall. And by making this announcement, that obviates the legal need for any further public notice on this application. So if you're interested in this application, please make a note of it, because there will be no more notices mailed. The signs will no longer be required to be posted, and there will be no publication in the newspaper. So that's literally an announcement that I would make, and your clerk secretary could make it, or anyone, the chairman, chairwoman could make it. And that's how you keep the public hearing open. If you don't make that announcement specifying a definite date, time, and place of that continued public hearing, and the application will remain open and be continued to be reviewed, then it's going to have to be renoticed again. It's going to have to be republished in the newspaper. All the signs are going to have to be changed and be reposted on the lawn, and the abutting property owner notices, the neighbor notices will have to be remailed. Okay.
All right, one other question, if you don't mind.
Sure.
Does the public hearing information also apply to government agencies? Let's say the DPW sends info after the public hearing. Is that okay to consider?
No, it's not. Not okay. Think of it like the Amber Heard Johnny Depp trial. Once you close the public hearing, the ZBA is now like a jury deliberating. And the DPW, as important as the superintendent of your highway department or Department of Public Works is, and his input could be, critically important. You've got to get it while the public hearing is open, because she is a fact witness, and you want the DPW superintendent testimony or report to be a part of the record, because it's critically important. And also out of fairness to the applicant, because what if your highway superintendent, is not the sharpest tool in the shed, and maybe he has a track record of making mistakes, and you've got a very sharp developer represented by a very sharp attorney and a very sharp engineer working for the applicant, and the applicant would like to have an opportunity to rebut, to challenge the report, the recommendation, the opinion given by your highway superintendent. So it absolutely must be during the public hearing. Same goes for your building inspector. I know a lot of municipal land use boards will close the public hearing, then they'll have a conversation with the building inspector. Not appropriate. Not appropriate. Building inspector is a fact witness. You are actually a jury hearing an appeal by a denial from the building inspector. So the building inspector denied an application because the building inspector said, I can't give you a building permit because you need area variances, or you need a use variance, or you need a special use permit. And so now you, the ZBA, are like a jury deciding whether or not the building inspector, was wrong or right, or not necessarily wrong or right. You're also there to provide relief if it's appropriate. If it's appropriate, you're like a safety valve. So just because you're granting area variances doesn't mean you're finding that the building inspector is wrong. You're just allowing some relief to the developer, or the applicant, from the strict adherence to your zoning regulations. So don't think of it like you're reversing. When you reverse a building inspector by granting area variances that the building inspector denied the building permit application because she has to. Do we have any women building inspectors in Rockland? I like to use she once in a while. So she, the building inspector, may not, does not have the luxury to vary from the bulk regulations. So the building inspector must deny a building permit if area variances are required. So you understand that, right? Building inspector doesn't have the legal authority or power or jurisdiction to vary from the bulk regulations. That's why they're called variances, because you're allowing a development project to vary from the strict adherence to your local zoning regulations. Building inspector must comply with them 100%. So therefore, the building inspector has to deny a building permit application if it requires area variances. So it goes to you, and you can reverse the building inspector and say, we went through the 5 considerations and we find that there's an appropriate finding here that the application has weighs in favor of granting the area variances after going through the 5 considerations, and we're therefore reversing the building inspector's denial. And that's essentially what you're doing. So that's why you can't even hear from a building inspector after you close the public hearing. Nobody except your attorney. Your attorney is the only one you can hear from after you've closed the public hearing. So you can always receive legal counsel from your attorney, not from the applicant's attorney, or not from the neighbor's attorney. Seriously, because what I see sometimes is you close the public hearing and your legal counsel or your chairperson will say, hey, okay, we're going to close the public hearing now, and we'll allow the applicant's attorney to submit a legal brief to the board, and we'll allow the the objecting neighbor's attorney to submit a legal brief as well. No. The only information you can get after you close the public hearing is from your attorney, the ZBA attorney. That's it. So if the applicant's attorney wants to submit a legal brief or further, argument in support of the application, then you got to keep the public hearing open. The same thing goes for neighbors, attorneys, or neighbors who want to submit. You got to keep the public hearing open to allow them that opportunity. Okay? Anything else about public hearings? If something pops up later, that's okay. All right, so the area variance considerations. The first one is you have to consider whether an undesirable change will be produced in the character of the neighborhood, or a detriment to nearby properties will be created by the granting of the area variance or variances. So again, whether an undesirable change will be produced in the character of the neighborhood, or a detriment to nearby properties will be created by the granting of the area variances. I know some of you are going to say, well, who's to say what's undesirable? Who's to say what a detriment is? Well, you're the ones. How do you wrestle with this? You look at the surrounding properties, the surrounding buildings. How big are they in comparison to their lots? Have you granted similar area variances in the past? Because you hear the word precedent. It is something that you have to be aware of. What does precedent mean? If you have in the relatively recent past approved of an application with similar facts, it's going to be hard for you to deny that similar future application. It doesn't mean you're forever bound by previous error. There's New York State judicial opinions, judicial case law that says a zoning board of appeals or land use board is not mandated by, what's the phrase, a principle of blind adherence to precedent to forever repeat previous errors that the ZBA made. So let's say an application did go before you, and you, with hindsight, gosh, maybe we shouldn't have approved that application. Well, the way you could deny a similar future application is by differentiating that previous application. You got to find a reason how those two applications are different. And there's usually something in a land use application that makes them different, because land by its very nature is unique. It's very rare to see subdivisions. I mean, I know they have them out in Levittown. Long Island is the famous subdivision, the late 1940s, early 50s. They had these cookie cutter subdivisions post World War II, boom, where literally every lot is exactly the same size. It's completely flat. You have 10 square miles of complete flatness. The roads are all cookie cutter, perfectly aligned. Every house exactly the same dimensions. Those types of subdivisions are rare. You certainly don't see those anymore. But even Levittown now, every house is a little bit different because every house has added their own little addition, and things look a little different. But there's also something else that you can differentiate an application on. So how can you differentiate an application? The uniqueness of the land, because land by its very nature is unique from one lot to another. To the passage of time. Just by the passage of time, neighborhood sentiment has changed. There may be some things going on down the street that have changed the dynamic, the land use dynamic of the overall community. So you have to find something to hang your hat on to say why this new application should be treated differently than that previous application. Although they look similar, you got to try to find a difference if you plan on denying the new application where the previous application, again, which looks to be similar, you approved. If you can't, then you may be bound by precedent. So precedent can play a part. It's not as onerous a fearsome principle of law that you need to quake when sometimes you hear objecting neighbors will try to get you to deny an application, because if you approve this, then you're going to have to approve all kinds of applications that come before you that are asking for these types of variances. Again, precedent is something to consider, but again, for at least those two reasons, the legal principle of precedent is not as fearsome a concern for a zoning board of appeals, but it is something that you should attend to. Okay. Any questions on that?
I'm sorry, there's actually a question which you unknowingly answered very well, in my opinion, but I'll read it anyway. Can you deny a variance because you don't want to establish a precedent where none exists before? That is, you don't want to open a Pandora's box of ill effects.
Well, that's what consideration one touches on, whether an undesirable change will be produced in the character of the neighborhood or detriment to nearby properties will be created by the granting of the area variance. Let's say the answer is no. Well, if you're saying, well, we don't want to grant these area variances because we're afraid, we're going to get we're going to open the floodgates for lots of similar applications that are going to start, coming in through the building department, doorway. Well, if an undesirable change will not be produced in the character of the neighborhood and a detriment to nearby properties will not be created by the granting of the area variances, then why are you concerned about precedent? So you really have to look at your considerations and answer them. And if, again, a majority, again, there's no black and white line, but let's say if a majority of the considerations you find unfavorable, then that's your basis to deny the application, not on precedent. The word precedent does not appear anywhere in the considerations, but it's underlies, underlies consideration number one. There's also a third consideration, which we could touch on, even talk about now, is whether the requested area variance or area variances are substantial. So whether the requested area variance is substantial. Well, if you find it substantial, that's kind of you saying we should deny this because we don't want to establish a precedent, right? You following me? So if you find that the requested area variance, or some of them, or one of them is substantial, and you find that an undesirable change will be produced in the character of the neighborhood if you grant the area variances, and a detriment nearby properties will be created by the granting the area variances, therein lies your foundation to deny an application. And again, that's how you address the precedent concern. And let's see, and here's another consideration. Now, look, we're touching on a third consideration already. Whether the proposed area variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. So that's another way of addressing the concern you have of establishing a precedent that's going to paint you into a corner. Okay, but no buts on that. But I do want to talk a little bit more about that one I just mentioned. We don't have to take these in any particular order. So do any of you have any questions about whether an undesirable change would reduce in the character of the neighborhood or detriment to nearby properties created by the granting area variances? If you don't, let me throw this at you with some guidance. If you have an objecting neighbor that is insistent that her property values are going to substantially diminish, her property value is going to plummet if you grant these area variances and approve of this application, well, she's just a layperson. You know, say, okay, madam, miss, neighbor, objecting neighbor, what is your basis for that? Well, if she brings in a New York State licensed property appraiser and the property appraiser submits a report under her signature and seal as a New York State licensed property appraiser, that if these area variances are granted, that the neighbor's property value appraisal valuation will substantially, diminish. Well, you've got something there that you really need to pay attention to. So that's an example. Now that only has to do with that has to do with the detriment to nearby properties. Undesirable change produced in the character of the neighborhood. Again, if someone is proposing, a McMansion, a monstrosity, where the typical home and the surrounding lots are 1,500 square feet, and what's being proposed is 3,000 square feet, twice the square footage of the average size of every nearby lot. And lots within 500 feet or even 1,000 feet are typically 1,500 square foot homes and 1.5 stories. And this guy's proposing 2.5 stories, 3,000 square feet. Well, I think a reasonable person can say that's going to be an undesirable change produced in the character of the neighborhood. But then again, is it? They always say you don't want to be the smallest house on your block, right? I don't know if you ever heard that expression, but generally speaking, bigger homes increase value. Theoretically, I'm not a licensed real property appraiser, and I'm not a licensed real estate broker, so I don't know if that's true, but I've heard the expression that you don't want to be the smallest house on your block because no, it's the opposite. It's the opposite, Adam. You can correct me. You don't want to be the biggest house on your block. So correct the record. Please correct the record. You don't want to be the biggest house on your block, because by having the biggest house on your block, you're increasing the valuation. Theoretically, I'm not saying this, I don't know if this is true, but theoretically, you're increasing the property valuation of all of your neighbors by having the biggest house on the block. Anyway, so let's move past that factor, the undesirable change produced in the character of the neighborhood, detriment to nearby properties. Does anybody have any questions on that consideration, that factor? Okay, so the next factor or consideration, this is a good one, and you really need to explore this with your applications. Whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than by the granting of the area variance or area variances. So again, whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than by the granting of the area variance or variances. This is where you need to be active participants on your board. You really need to cross-examine the applicant. You need to put the applicant to her proofs and say, okay, you say you need a 3,000 square foot house. Well, let's look at your floor plans. Why do you need, a 500 square foot bedroom? Is that a big bedroom? What's 500 square feet? What's 20 by 20? Or 25 by 25? Anyway,
500 square feet is probably a pretty big bedroom.
That's a pretty big bedroom.
Small apartment.
500 is a pretty big. So, why do you need a 500 square foot master bedroom? Why do you need a his and hers, bathroom? Each side of the bathroom is, 75 square feet or 100 square feet, so on and so forth. You really got to put the applicant to her proofs, have the developer present, real testimony, documentation. If the applicant did not submit a floor plan, then by all means, you should ask for a floor plan, so the applicant can justify why they need such a large house relative to her neighbors. So whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than by the granting area variances. I'm repeating the consideration again. So what about, okay, well, we're proposing an addition on our house because we have an expanding family, we need more bedrooms. Okay, why do you need, again, your children's bedrooms are 250 square feet. So really explore the floor plan. Do they need 10-foot ceilings? They need a building height variance. Well, why do they need 10-foot ceilings? The minimum state building code requirement is 8 feet. You got to have a minimum 8-foot floor to ceiling. Why do you need 10 feet? Just explore why the house or the building, if it's a commercial building, why does it need to be this big? Any questions about feasibility for the, and also feasibility. All right, so let's say the average home in the surrounding neighborhood is 1,500 square feet, and the applicant is proposing a 2,000 square foot house, and the bedrooms are very modest size, very small bedrooms. Let's say they're proposing, 8 feet, 10 feet by 10 foot bedroom. I think that's pretty small bedroom, 10 by 10. That's the size of a standard tool shed, just to give you a sense. 10 by 10. Picture a standard tool shed, the ones that you buy at Lowe's. You plop it in your backyard. That's 10 by 10. You can't really get much smaller than that. So, you have to consider the feasibility to the applicant. He wants, he's got 3 kids. They want 4 bedrooms. They want a master bedroom and they want a bedroom for each kid. And they're proposing 10 by 10. You add it up, the kitchen maybe is, a modest sized kitchen. So on. You really got to explore, the feasibility and really cross-examine the applicant. Don't just accept what the applicant tells you what the applicant's needs are. Explore it and ask for documentation to back up whatever oral testimony the applicant is giving. Don't just accept the oral testimony. Ask for documentation, reports, studies. I know I'm focusing on residential. Same principles apply for commercial. You may need some help with the commercial from your village or town planner or your village or town engineer. when it comes to the commercial projects more so than the residential, but same principles apply. Just cross-examine the developer why a building needs to be the size that's being proposed. So any questions on the factor about whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than by the granting of the area variances? Any questions on that consideration?
There is a question which is, I think, related to it. Who determines the list of items required to be presented for any variances? Emphasis on required.
Certainly the ZBA is the final word. Just because your local law does not require certain information or documentation or types of plans or drawings does not mean that you, the ZBA, cannot require it. A good example is architectural drawings, where area variances are typically side yard setbacks, rear yard, front yard setbacks. What does that mean? What's a front yard setback? A front yard or a yard setback, front yard, side yard, rear yard setbacks is the distance from the front of the building to the front property line. That's a front yard setback. Whether your local zoning code regulation is 10 feet, 15 feet, 25 feet, 30 feet, depends on the zoning district and the proposed type of use and occupancy. So if it's a single family detached residence, the front yard setback in an R40 zoning district may be 30 or 40 feet. It depends on the municipality. Every village or town has their own set of zoning or bulk regulations. Side yard setback, again, is the distance between the side of the building and the nearest side property line. Same thing with the rear yard setback. The rear of the building to the nearest, to the rear property line. That's your rear yard setback. And there's a minimum number of feet. It's either going to be, it could be as low as 5, 10 feet or higher. So whatever that minimum yard setback is, must be met. If it's not met, then the application needs a variance. So what sometimes you'll see is you'll only get what's called the site development plan or a site plan or a survey. It'll show the building footprint on a survey. It'll show the rear yard setback, front yard setback, side yard setback. It'll show where the building footprint is encroaching into those setbacks. So let's say the side yard setback is a minimum 20 feet and the footprint is 15 feet away from the side yard. It's encroaching. It's encroaching into the minimum side yard setback. So let's say it's 15 feet away from the side. It's 15 feet away from the side lot line when 20 feet is the minimum. So you need a 5-foot variance. You'll typically sometimes see an applicant only present the survey without any architectural drawings. I don't know what your municipality requires, but some municipalities require architectural drawings. And I do think it's a good idea for the reason we discussed a few minutes ago, which is how else are you going to see the floor plans? You're not going to see the floor plans if you don't have architectural drawings. So that's one good reason why you should require architectural drawings. Is it required by law? No. Your local zoning code may require it. When I say it's not required by state law does not require anything. It's something that's dictated by your local zoning or building code regulation. So again, what must be submitted as part of a ZBA application is set forth in your zoning code. But a ZBA, again, can require other information, other drawings, other plans. You may get an applicant giving you some pushback and say, whoa, hold on. We submitted everything that your local zoning code requires. So here's the list right from chapter 167 of the village of whatever, Rockland County, New York. This is what your village zoning code says. We submitted everything. You cannot now require us to submit this additional plan or architectural drawings that's not set forth in your local zoning code. You may get that argument, and your response is, okay, we understand that, but a question has been raised concerning the size of the bedrooms, why you need a 3,000 square foot house. We don't have architectural drawings. We would like to see the floor plans. We want to understand why you need what what is encompassing the 3,000 square feet. And your survey that just shows the footprint is not giving us that information. So I think a court, if you were legally challenged and you were sued, I think a judge would be reviewing your request and would determine whether or not your request is reasonable, whether or not it's rational. And I think if you're asking for, again, this is just an example. If you're asking for architectural drawings because you want to understand the square footage that's being proposed, I think that's certainly rational and certainly reasonable. And I think a judge would find you to be appropriately asking for the architectural drawings. For example, floor area ratio. Let's talk about floor area ratio. We talked about building height. We talked about yard setbacks, front yard, rear yard, side yard. But we didn't talk about floor area ratio. Most municipalities have a regulation in your zoning code called floor area ratio, or FAR, or FAR. And all that is it's a totaling of all square footage of the building. Sometimes the municipality will subtract out stairwells. Certain improvements may not be included in the calculation for floor area ratio, but leave that to your building inspector. But just for purposes of this session, it's the total square footage of the building. So if it's a 2-story building, whether it's a residence or a commercial building, it's the square footage of the first floor plus the square footage of the second floor. If there's a 3rd or 4th story, if it's a multi-unit apartment or a condominium, or if it's a commercial building with several stories, you add up all of the square footage for every single floor and divide it by the total lot area. Keeping in mind that some municipalities may subtract out from the gross lot area, they may subtract out areas such as wetlands may be subtracted out, steep slopes may be subtracted out, conservation areas may be subtracted out. That's not your concern. That's something for your building inspector or your village or town planner or village or town engineer will do the calculations for you. The applicant will do the calculations first, but your building inspector, village or town planner, village or town engineer should be double checking the applicant's calculations. So you take the total square footage of the building of all floors, divided by the total lot area or net lot area, if you have to subtract out for these, conservation areas or wetlands, steep slopes. And that calculation will bring you give you your floor area ratio. Floor area ratio. What it really amounts to is, what is FAR? It's essentially the 3-dimensional cubic size of the building. It really gives you, the ZBA or the municipality, a sense of the size of a building in relation to the lot. So you may be dealing with a 3,000 square foot house, but if it's on a 40,000 square foot lot, that's not a big house. I mean, it's a nice size, but it's not a huge house because the floor area ratio is small. 3,000 square foot house, 1,500 square feet per floor, 2 floors, 1,500 square feet, 3,000 square feet divided by 40,000 square foot lot. That's a very low floor area ratio, very low FAR. It's a relatively small house. But if you're proposing that same 3,000 square foot house on a 10,000 square foot lot, that's a 33% floor area ratio, right? No, 30%. It's a 30% floor area ratio, which that might actually be what your floor area ratio maximum is for that zoning district. So if you're in an R10 zoning district, residential zoning district, that means your lot size must be a minimum 10,000 square feet in an R10 zoning district. If you're proposing a 3,000 square foot house, that's a 30% floor area ratio. I would venture a guess that your municipality's maximum floor area ratio is probably 30%, might be 25%. It depends on the municipality. There's no state law on that. So, so the reason I bring up those floor area ratio is, what were we talking about, Adam?
Well, what's required?
Oh, feasibility. As far as what you can require as a ZBA in terms of documentation, drawings, plans, reports, and so on. as long as it's reasonable and rational and it relates to the application, something that is substantively relevant to these 5 considerations is fair game. Let me give you an example of would not be appropriate, where sometimes you'll get a ZBA member that will ask for how much are these properties being listed for. We want information relating to the financials, financial information relating to the applicant or the developer. And we'd like to know what you're going to be listing these property, this building for sale for, or how much of a rent are you going to be charging if it's a commercial building. And you're asking for that documentation. If I were your attorney, I would respectfully interject and say that is not an appropriate request. If it were a use variance, it would be an appropriate request, but not for an area or bulk variance. So if the information or documentation or plans or drawings you're asking for relate to one of these 5 considerations and in an area that you're exploring as part of these 5 considerations, then it's appropriate.
I just toss out also, if you are concerned about one of those areas, just make sure you're connecting that on the record. Don't just say, give us architectural drawings. Tell them we want to know what your floor plan is. We want to know this, therefore we need the architectural drawings.
Right. Not because you're nosy, because you're proposing a very large house or a very large commercial building, and we want to see how you're just, what is taking up that 3,000 square foot space, or if it's a 50,000 square foot commercial building, what is going to be in that space that you need so much room.
We have several good questions here, and I don't want to discourage questions, but I'll ask them, but I also want to just point out we are past the halfway point. So I'm not sure if we've gotten quite to where you want to be.
Well, we're again, I would say about 8:30, we're going to finish with area variances. So we've touched upon 3 of the 5 considerations. We've already finished them pretty much. So why don't you throw a couple more questions at me?
I'm going to take them out of order. How can the requirements be standardized and not simply per application? All information should be presented to understand full scope. Otherwise, the public hearing stays open and the applicant may be forced with multiple meetings to satisfy our needs.
Well, that's good. You want to be fair to the applicant. You also want to be fair to the ZBA in the process, because you may have busy agendas and you have half the items on the agenda are not, the submissions are complete because there's information, documents, plans, drawings are missing that you typically require. The answer is adopt a local law. If it's not already in your local zoning regulation, go to your mayor or supervisor, town board, village board of trustees, and you say, hey, we would like incorporated into the zoning code a list of required submissions for a zoning board of appeals application. There's your answer. That's how you do it. Okay.
There's another question. Does evading another regulation count as feasible? Say an applicant wants variances from multiple small lots instead of combining lots because a combined project would need to meet affordable housing requirements.
This is one of those specific questions about a particular case that I'm not. Affordable housing is a creature of local law. I know there's also state law that governs certain types of Section 8, things of that sort. That's well outside the scope of even a zoning board of appeals, really. That's something that usually your town board or your village board deals with, affordable housing. Your 5 considerations do not consider affordable housing. It's not part of something that you're mandated to consider as one of your factors of weighing an application for area variances. However, you did bring up a good general question, which is if you have an applicant or developer that owns several abutting lots that are substandard in size, and if he combined them all or some of them, maybe he's got 10 lots. If he combined 5 of them and ended up with 2 lots instead of 10, he would not need any area variances That's a fair question. That's a fair question to ask the developer. Say, hey, you got 10 lots, all substandard. You want these very large variances. You want to build 10 single family detached homes on each of these 10 lots. We get that. You're going to make more money that way. Okay, we appreciate that. But, these area variances that you're asking for are quite, immense, very, 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 very substantial. I, as one ZBA member, am very, very, very uncomfortable approving this because you do have a feasible option. And that feasible option is you can merge some of these lots. I'm not saying you have to merge 5, lots to make 2 instead of 10. So you have 5 lots merging here, 5 lots merging here to make 2 lots instead of 10 and not need any variances, but maybe you can merge, 3, and well, the math won't work out, but you get my point. Maybe you can merge 3, 3, and 2, or come up with something that's not 10 lots. Compose 3 or 4 lots or 5 lots. Listen, they're just paper lines on a subdivision map. You can draw them any which way. Some of those lots might have homes on them already, but anyway. So that's something that certainly could be explored in that scenario. And I think it's a fair question to ask the developer.
There is a question which been up for a while that I ignored because we had moved on from the subject, but I'll ask it now. I think this is going back to whether after you close a public hearing, can you get government and other agencies' comments? And the question was, would this apply to a Corps of Engineers report?
The Army Corps, U.S. Army Corps of Engineers is an outside agency. Again, the only information you can receive, testimony, report, correspondence, whether it's even if it's a U.S. Department of Homeland Security, if it comes after you close the public hearing, you cannot consider that information. Now, if it's something critically important, let's say it is something from the U.S. Department of Homeland Security, and it really is like a blockbuster information or report, there is a mechanism where you can reopen the public hearing. I'm not going to go into it now. Your legal counsel can guide you, but there is a mechanism. It's actually quite simple. A unanimous vote of all members present at a meeting, not the entire board. So let's say it's a ZBA of 5 members. 3 members is a quorum. So if you have a 5-member ZBA, 3 members are at a meeting. If it has to be unanimous, so all members present. So if 3 members vote unanimously to reopen a public hearing, then you can reopen the public hearing, and then you have to pick a date. You don't do it on the spot. You have to pick a future date in the future, set the date of that future public hearing. It has to be renoticed, has to be republished. Neighbor notices have to go out. The whole thing as if you're starting the public hearing from scratch. So there is a mechanism to reopen a public hearing.
Okay.
Okay.
Yep. All right. We have 2 other questions, but one is for about interpretations, and the
Yep.
other one is, it's an interesting question, but I think it can wait until the end of you get to the end of the bulk area variances. So
Okay, yeah, because
we'll see those
we're
2
going to touch on
questions, but we'll
interpretation.
get to
We only need a
those
few
in a little
minutes.
while.
Okay, so the next consideration is whether requested area variance is substantial. There's no black and white line. I'm not going to spend a lot of time on this. A good applicant's representative, the applicant herself will do her homework, will go to the building department or the boards and commissions office, wherever your zoning board of appeals decisions are stored, and get copies of all previous ZBA decisions approving and denying area variance applications, and present to you, hey, the area variances that we're requesting are very similar to area variances that you've approved in this neighborhood over the past several years, similar projects, similar homes, or similar commercial buildings in this neighborhood. So substantiality is what I'm getting at, is relative. And if you yourself don't do the work, ask the applicant. to do her homework. Have her do the research and present to you why these area variances are not substantial by going into the building department of the Office of Zoning and Planning and boards, and present to you other applications that you've reviewed that are similar applications that you reviewed and either approved or denied. And but you as a ZBA member, usually you've been on the board for, generally ZBA members are there for many years. It's very rare that you have a land use board member that's only a couple of years on a board. It's usually, I think they're usually like 5-year appointments, or planning boards. I think whatever the membership is, if it's a 5-member board, I think the minimum number of years you have to be on is 5 years. I think it's 5 years. If you have a 7-body board, then it's 7 years. So you already have an idea of what projects you've approved in the relatively recent past, just by being on the board. So right there, bring your knowledge to the table, but present it during the public hearing. Okay. Yeah, we're doing pretty good on time. Site visits are fine. But if there's a quorum of you at a site visit, it's technically a meeting of a public body that's subject to New York State open meetings law, which means you have to notify the media that there's going to be a meeting of the Zoning Board of Appeals at a certain date, time, and location, which is going to be 123 Main Street. It's not going to be Village Hall or Town Hall. Seriously, if there's a quorum of you at a site visit, if you discuss the business of the board at that site visit. Now, theoretically, if there's a quorum of the ZBA at a site visit, and all you talk about is your kid's softball game or soccer game or basketball game, social things, nothing to do with the business of the ZBA, nothing to do with the Zoning Board of Appeals, technically, you're not in violation of the open meetings law. So a quorum of you can go to a site visit, and you will not be in violation of the open meetings law if you did not give prior notice to the media about that meeting. Again, if you do not discuss any business of the ZBA, anything that has to do with the ZBA, whether it's applications or just ZBA business in general, it doesn't even have to be about that project. If you're at 123 Main Street, and while you're at the site visit, there's a quorum of you present, and you talk about ZBA procedure that has nothing to do with 123 Main Street, that's the business of the board. You're in violation of the open meetings law if you did not give proper notice to the media, at least, 3 days in advance of the meeting. So my advice is site visits do not have a quorum. If it's a 5-member ZBA, 2 members at a time, that's fine. You can talk all you want. You can even talk about the application if you want. You can, seriously, if there's not a quorum, at the site visit. But be warned, if the information that you acquired during that site visit is going to play a part in your own assessment or evaluation or deliberation over that application, whether to approve it or to deny it, or whether or not it would be appropriate to impose certain conditions or not, then that information that you acquired, even if it's visual information, you must disclose it during the public hearing. So the next time you're in front of the ZBA, after you did your site visit, a week or 2 later, you're at the ZBA meeting, you say, hey, I went to the property on a site visit, and I noticed that there was a steep drop in the back of the property, or I noticed this big tree that was right next to the, very close to the side of the house, whatever you observed. If it's something that's going to play a part in your own evaluation or assessment or deliberation over that application, then you must disclose it during the public hearing. But then again, if it's not going to play a part at all in your evaluation, your assessment, your deliberation as a ZBA member over that application, let's say you saw that the driveway, had some children's chalk drawings on it. You observed that. You saw it was a beautiful drawing on the driveway. It was, wow, that's some artistry there. But that's not going to play a part in your evaluation of the application. No, you do not need to disclose that. And please don't. Don't drag the meeting on longer than it has to be. Okay. So substantiality is not subjective. It's not subjective. It should be objective. So substantiality should be objective. It should be empirical. It should be based upon what its surrounding properties, how the surrounding properties are developed, what size buildings are on the surrounding properties relative to their lots, density in the neighborhood, things like that. So that's all I have to say about substantialness of area variances. Unfortunately, there's no black and white line. A 10% variance, a 5% variance, a 30% variance, a 70% variance, are they substantial or not? You're not going to get an answer from me. You're not going to get an answer from New York State judicial case law. It has to be based upon evidence in the record. You have to get into the record what is going on with the abutting nearby properties and how they relate to what's being proposed. Okay, and that may require you doing some homework. You may, ask your clerk secretary, hey, can you, get us copies for the past 3 years, all ZBA area variances that we have approved or denied over the past 3 years for similar type projects. Give your clerk secretary some guidance. What would be a similar type project? Usually it's not that hard, but you certainly are encouraged to do your own homework as well. But again, you got to make it part of the record. You're not going to do this on the side. Whatever your clerk secretary presents to you, you put it on the record. Okay, here we have a pile of 15 decisions over the past 3 years and reference them on the record. Anything about substantiality, substantialness? Okay.
Not right now.
No, the next to last factor, and we're almost done. We're not going to spend a lot of time on it. Whether the proposed area variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood district. We're not going to talk about SECRA, State Environmental Quality Review Act. State Environmental Quality Review Act will take up 2 sessions, 3 hours sessions. But this much I want to tell you about SECRA. If area variances generally are exempt from environmental review under SECRA because the New York State Commissioner of the State Department of Environmental Conservation, so the DEC, the Department of Environmental Conservation, adopted regulations that are state law, and you can't modify them. You can't detract from them. You can't add or you can't change them or waive them. This is the law in New York State. So I'm going to read you the law. These applications are exempt from environmental review. It's also called Type 2. A Type 2 action means under SECRA, under the State Environmental Quality Review Act, Type 2 action means exempt from environmental review. No environmental review is necessary because the New York State has already determined that these applications will not have a significant adverse environmental impact, And they are an application that seeks to construct or expand a single or 2 or 3 family residence on an approved lot. So if someone is seeking area variances to expand a single 2 or 3 family residence on a lot that already exists, exempt from environmental review. State has already determined there will be no potential significant adverse environmental impact. If an application is seeking to construct or expand or place a minor accessory or a pertinent residential structure, exempt from environmental review. If it's seeking area variances for construction or expansion of or relating to a single 2 or 3 family residence, or it's only seeking setback or lot line variances. So if it's only asking for setback or lot line variances, those are all exempt from environmental review, which those 4 right there, those types of projects, I'm guessing is the overwhelming majority of your applications that are coming before you. So back to consideration number 4, whether the proposed area variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood district. Well, quick answer is, if it's exempt from environmental review, the New York State Department of Environmental Conservation has already determined statewide that there will be no potential for significant adverse environmental impact on the environmental conditions in the neighborhood district. Now, I know that word physical is in there. I think that kind of goes hand in hand with the environmental conditions, but what you'll sometimes get is from an objecting neighbor, and this is how you can handle the physical, whether it'll have a adverse effect or impact on the physical conditions in the neighborhood. In other words, leaving aside the environmental, because we address that, because it's probably going to be type 2, unless it's commercial and it's over 4,000 square feet. If it's a commercial use and it's over 4,000 square feet, then it's subject to environmental review. And either more likely the planning board is going to be lead agency, and the planning board will undergo the environmental review under SECRA. You don't need to worry about it usually. It's very rare that a ZBA is the lead agency under SECRA, very rare, but the day may come. That's another session. We're not going to go into it now. But so keep in mind, if the construction that's being proposed is under 4,000 square feet of gross floor area and it's commercial, non-residential, less than 4,000 square feet of gross floor area that's being proposed to be developed or built or constructed or erected or renovated, that is also exempt from environmental review. Exempt. Their state has already determined there will be no significant adverse environmental impact caused by that. So that addresses consideration number 4. But let's go back to the physical aspect. If you have concerned neighbors over drainage, drainage is a hot I always say 90%. It's probably more than 90%. 97% of your objecting neighbors are going to be concerned about surface water runoff or drainage. I'm going to have water in my basement. If you allow this house to be built, I'm going to have a pool, an indoor pool in my basement. My basement's going to be flooded. My backyard's going to be a lake. That may or may not be true. But one of the conditions that I recommend that a ZBA impose uniformly for any application, why not, is that there will be a 0 net increase in surface water runoff. 0 net increase in surface water runoff. Again, 0 net increase in surface water runoff. Your village or town engineer, your village or town planner, or even your building inspector, of course, will know what that means. Well, you'll say, well, who's going to decide that? You make it conditioned upon the satisfaction of that criteria, of that condition that you will impose as part of your approval. It must be satisfactorily met as determined by your village or town engineer or your village or town planner or even your building inspector. In that order of preference, I'd rather have that be signed off by an engineer, secondarily a planner. I love you planners, you guys are awesome. But listen, an engineer is a New York State licensed professional engineer. You know, if she's saying there's going to be 0 net increase in surface water runoff, that's as good as gospel. You know, planner's great, building inspector's great. That's okay too. All right. So that's how you handle consideration number 4. And the last one is easy. Whether the alleged difficulty was self-created, which consideration is relevant to the consideration of the Zoning Board of Appeals, but shall not necessarily preclude the granting of the area variances. In a nutshell, nearly every application for an area variance is self-created hardship. It's a self-created difficulty. That's okay. It's only one factor. Remember I told you, you have 5 considerations, 5 factors. Applicant doesn't have to satisfy all 5. She can fail 2, even 3, maybe 4, even under the right circumstances. But an applicant certainly does not need to meet all 5 of these considerations. So I can tell you right now that 97% of your applications are going to be self-created difficulties. They are going to be self-created difficulties, and that's okay. You can say, okay, we recognize that it's a self-created difficulty, but looking at all the other factors, all the other considerations, weighs in favor of granting the application. So the only example I can give you of a self-create of a hardship or a difficulty that's not self-created. By the way, they don't use the word hardship anymore. The state statute uses the word self-created difficulty. So an example is when we had, after Superstorm Sandy, many years ago, Superstorm Sandy, the FEMA flood maps drastically changed. In new construction, first floor elevation of all new construction had to be a certain number of feet above the mean flood something or other. So if you had a house on the Hudson River and you wanted to bring it out of the flood elevation, I can't think of the terminology now, but you let's say you wanted to renovate your house, you wanted to expand your kitchen, you're going out to the side, you're going out to the rear, you weren't going higher, you weren't proposing bigger floors, you weren't expanding your height at all, but you just wanted to expand your garage, your kitchen, your mudroom, you wanted whatever it was, a bedroom off to the side. But because you were renovating your house and you're in this FEMA flood zone, let's say you live on the Hudson River or on one of these streams or creeks, maybe you have to, I think on certain like Minneskiango Creek, I think now you have to raise your first floor now a few feet to be out of that flood elevation. So now you need a height variance. You need a height variance now. It's like, well, arguably that's not a self-created difficulty because FEMA changed the flood maps and you're raising your house get out of the flood elevation, whatever, you're doing something good in a sense, you're complying with the FEMA flood regulation. That arguably is not a self-created difficulty. So that's it for the area variance considerations. So we're going to touch upon the other three things that you guys do as zoning boards of appeals. But, we've spent 75% of our time on area variances because 97% of your applications are going to be area variances. Any questions on area variances?
Well, there is a question, and it's applicable for almost anything for a ZBA, but it's asked about area variances. And a good general question, how do we deal with hostile applicants? Asking questions like, why do you need a 400 square foot bedroom can result in hostile responses from applicants. In the end, these are still our neighbors or potential neighbors, and we are faced with an increasing push to challenge bulk and area use.
How do you deal with hostile applicants? Well, hostility is never, the chairperson is like the sergeant at arms of the meeting. If an applicant's refusing to give you information, leaving aside that, I assume what you mean by hostile applicant is that he's refusing to provide further information, plans, drawings, document, whatever. Maybe you want a traffic study. A little bit unusual for a ZBA to ask for a traffic study. May even be perhaps inappropriate if it's a residential proposal. But again, if it's a 100-unit condominium complex, but again, if it's a 100-unit condominium complex or a residential apartment building, it's definitely go to your planning board, and it's definitely subject to SECRA. Anyway, so what kind of hostility are we talking about? I'm sorry.
Well, the person followed up saying, no, yelling and insults and verbal attacks.
Oh, well, that's an easy answer. I mean, you asked, I thought you meant hostile in the sense of, not refusing to provide certain answers to certain questions or, information, drawings or plans that you're asking for. If he's just being, I'll call socially hostile and disruptive, well, the chairperson certainly has the power to control the meeting and to ask that person to lower his voice, to please be respectful, to please not interrupt other people when they're speaking, so on and so forth. And if the applicant refuses, you ask him nicely, a little more firmly, one more time, and then if he still refuses, you warn him and say, one more time, I'm calling the police. You can call the police. I've been at meetings where the police have been called, where a particular attendee, usually not an applicant, but an objecting neighbor, someone in attendance. They're just, constantly shouting, disrupting, just being generally rude and disruptive, where the police had to be called. But I would say at least 2 warnings before you call the police. I think 2. 1 gentle warning, second one a stern warning. If you do it again, I'm going to have to call the police to maintain order. And if it happens a 3rd time, then I think you're safe in calling the police. I hope that answers your question. That's an easy question. It's just like anywhere. If someone is disruptive, you give them a gentle warning, you give them a stern warning, and with the stern warning, you caution that person. If it happens again, we're going to have to call the police to maintain order. If they do it again the 3rd time, then and the rule isn't 3. I mean, you can give them 3 warnings, you give them 4 warnings, whatever you're comfortable with. Okay, anything else on area variances?
There's a few questions, nothing specifically about area variances, so I think perhaps we can hold them till the end.
Interpretations. This is easy. By the way, an application for interpretation is also exempt from environmental review in the State Environmental Quality Review Act, or SEQRA, SEQRA. You may hear some attorneys or developers and applicants, representatives, they'll sometimes say seeker. Same thing. I'm a SEQRA guy. There's plenty of seeker folks out there. So if you hear seeker, it's the State Environmental Quality Review Act. So an application for interpretation to the ZBA is where a building inspector gets an application for a building permit, he denies it, and the building inspector says, I cannot issue you a building permit because this project requires a use variance based upon this particular provision in our village or town zoning code. What you're proposing is not a permissible use, or it's prohibited. It's not a permissible use. So you need a use variance from the ZBA. The applicant looks at the provision in the zoning code and says, I'm sorry, building inspector, but I think you're interpreting this zoning code provision incorrectly. I don't think you're reading it wrong. This is what it means. That's called an interpretation. And so what an applicant can do is apply to the ZBA for an interpretation, not for a use variance. And by the way, the interpretation application doesn't have to be tied in with a use variance interpretation or determination by a building inspector. So the way interpretation application works is it starts with the building inspector, as all applications before a ZBA start with the building inspector. There's an application for a building permit. I cannot give you a building permit because you need area variances. You need to go to the ZBA to get area variances, or you need a use variance. You need to go to the ZBA to get a use variance. Well, the applicant can say for the use variance, for example, I disagree. This does not require a use variance. So I'm going to go to the ZBA and ask for an interpretation. I'm not going to apply for the use variance because as the developer, I know that an application for a use variance is extremely complicated and they're extremely difficult to obtain because New York state law for use variances is horribly stringent. I don't mean horrible in a bad way. It's enormously stringent and almost impossible to meet as an applicant. So in all likelihood, a use variance application is going to be denied, or it should be denied if a ZBA is following the law. Sometimes they grant use variances because they just don't care. They just want to approve it for whatever reason, and they just kind of put the law to the side. We'll talk about that very briefly. So the interpretation application to you says, ZBA, I want you to reverse the building inspector's determination that this project requires a use variance. And that's the application. It's usually presented with a narrative, like a letter or a narrative, maybe from an engineer or an architect or a surveyor or from an attorney, arguing to the ZBA why the building inspector was wrong, why he should be reversed. And then you have a discussion. There's no criteria, there's no factors, there's no considerations. You just have to be rational. You have to be reasonable, and you cannot be arbitrary and capricious. What does that mean? Well, just like the English language dictionary definition of arbitrary and capricious. I'm going to approve this application because I like the tie that the applicant's attorney was wearing at the public hearing. So I vote yes for this interpretation application. That's arbitrary. That's capricious. It's caprice. I'm going to approve it because I like the tie that the applicant's attorney was wearing. Or I'm going to deny it because the applicant's attorney was mean. Believe it or not, that's arbitrary and capricious because that's not one of your 5 considerations. Well, there are no considerations for interpretation, but I don't think the meanness of the applicant's representative is something that a ZBA should consider for any type of application, whether it's a use variance, area variance, or interpretation. So with interpretation, you're going to be largely guided by your legal counsel because it requires an interpretation of law. Your law is your zoning code. That provision in your zoning code is law. So your legal counsel, your ZBA attorney is going to guide you with that interpretation application. So that's all I have on interpretation. The good news also with interpretations is they are not required to go to to the Rockland County Planning Department. They're not required to undergo a GML review. They're outside the jurisdiction of New York State General Municipal Law sections 239 LM and et cetera. So interpretation application does not need to go to the county planning department for GML review. And it's exempt from SECRA, again, not required to undergo environmental review. Any questions about interpretation?
Yes, there is. And if you do send it to the county, planning department, I mean, they're kind of fun, so I like them. But
yeah, we're not going to talk about it now. Adam, you can call me and I can tell you why there's sound reason why interpretation applications are not subject to the jurisdiction of the state.
I wasn't disagreeing with you. I'm just
okay.
saying we do get them occasionally, and they're
they're fun. They are fun. I like them too because they're fun. All right. So what's the interpretation question?
It's kind of along with actually a follow-up, but I think it's a good question here. We are often asked to provide an interpretation of something in our municipal code that is unclear. If this repeatedly happens, does it make sense to alert the trustee board that it's a recurring issue and urge them to pass a zoning code change resolution to tighten up, clarify, or quantify the contested clause? Or should the municipality keep their code vague to allow for continued ZBA interpretations on a case-by-case basis?
Yes to one and absolutely no to number 2. So yes, I would strongly suggest bring it to the attention of the village board of trustees or the town board and say, hey, you need to clean up this provision on zoning code. Maybe you guys like having long meetings. I don't know, but it's always my goal to shorten agendas if I can. So if there's a type of application that is recurrently appearing before a ZBA and it has to do with, like you said, interpretation of a particular provision or provisions of your zoning code that are unclear, by all means, you should bring that to the attention of your legislative body, which is the town board or village board of trustees, and ask them to clarify it. The number 2 option, which is hey, let's keep it going. That sounds, no offense, but that sounds ridiculous. Why would you want to do that? I'll give you another reason why, other than abbreviating your meetings, by eliminating that lack of clarity, ambiguity in a local zoning code. So here's a second reason why you want to clean it up. Ambiguity in a zoning code, a local zoning law, village zoning code, town zoning code, any ambiguity. So if it's unclear, which means ambiguous, must be interpreted in favor of the applicant/developer. So keep that in mind. If your attorney says it's ambiguous, it's not clear, if there seems to be a general consensus that your provision is ambiguous, then it must be interpreted in favor of the applicant, in favor of the developer. That's the law, New York State law. It's a judicial case law. But any other interpretation questions?
Well, he had a follow-up, but also I wanted to ask you, if there's a situation where, if there's perhaps a provision that could be interpreted one of 2 ways, a building inspector says it's interpretation A, and then the ZBA rules, disagrees and says, actually, it's an interpretation B. I mean, I think in this situation, could the building inspector should at that point adopt the interpretation given to him or her by the ZBA.
Yeah,
I
thank
don't
you,
know in this
Adam.
particular instance, but
You're
maybe
absolutely right.
is the building
No, you're
inspector
absolutely
being
right.
stubborn?
Yes. Once the ZBA interprets a zoning code provision that was brought before them for an interpretation, and they interpret it as A instead of Z, that actually is now the law. It doesn't get embodied into your municipal code book, but it is now the law that is applicable to that very, very specific zoning code provision. And yeah, that's the answer.
So you shouldn't see
so
the
if there's-
exact same one more
Yes,
than once.
but the
You should-
exact, again, so if there's an interpretation by the ZBA, of a local zoning code provision, that interpretation for that specific, don't broaden it more than what the ZBA said. For that specific zoning code provision is now the law that must be applicable for that zoning code provision. It's not just for that application. And now that will now be applicable to all future applications. It's not retroactive. It's not retroactive. Okay.
Yeah, and there was a follow-up. How much collaboration should take place between a trustee board and the ZBA? Would this collaboration destroy the independent nature of the ZBA and the appeals process?
There's no collaboration at all. A trustee, like any government official that works for the village or the town, absolutely has a right to be heard, just like any concerned person or board. A local municipality, if the project is like within 500 feet of a municipal boundary, you have to send notice to the village or town clerk of that neighboring municipality. The neighboring municipality has a right to be heard, but that right to be heard is not binding. Same thing goes for your town board or your village board. So if the town board, let's say it says the town ZBA, town board adopts a resolution telling the ZBA, we want you to deny an application, you're not bound by it. You're not bound by it at all. It's just as if an objecting neighbor is asking you to deny an application. Just like your neighboring municipality, the village of the neighboring municipality, the village board of trustees adopts a resolution from the neighboring municipality telling you, the ZBA, that we want you to deny an application. You're not bound by it at all. You're not bound by it at all. In fact, the town board, if they're unhappy with the decision that you made, or the planning board, they could sue a ZBA and vice versa. A ZBA can sue a planning board or a town board. As a body, you have to have a resolution. As a body, you have to vote. Of course, if you're going to sue the town board because you didn't like a decision the town board made, you're gonna have to pay for your own legal fees. I don't think the town board's gonna pay for your legal fees because your village attorney or assistant village attorney or town or deputy town attorney, your legal counsel, is going to have to recuse herself because she will have a conflict of interest. Anyway, we're not gonna go down that road. But the point is, there should be no collaboration. The town board certainly has a right to be heard, just like anybody else. They don't have any special standing in front of a ZBA. Same goes for a planning board. And that's it. Okay. No collaboration.
Okay. There are several other questions, but I think they can be at end of topic type stuff.
Yeah, I'm going to touch on special. We did interpretation, special use permit. There's nothing in New York state law. If you have a special use permit application or special permit use or special permit, all means the same thing. I like special use permit or special permit use. That's the more technical term. Be guided by your local zoning code, because whatever that special use permit that's being proposed, there's usually criteria that are specific to that special permit use in your local zoning regulation. So let's say it's a proposed bed and breakfast. There's usually something in your zoning code that'll have special use permit criteria or considerations or factors, all means the same thing, pretty much, in your local zoning code that tells the applicant and tells you, as the reviewing board of that special use permit, what the application must submit, usually what an applicant must submit, what the criteria are, what the considerations are, what the factors are, what must be satisfied, what must be complied with to be able to grant a special use permit. So literally, this is going to be the end of special use permit. If you get a special use permit application, look to your building inspector or your legal counsel, your ZBA attorney, and say, is there something in our local zoning code that sets forth the criteria or the considerations or the factors or standards? A lot of times you'll see special use permit standards is a very common word that's used for special use permit standards. Is there anything in our zoning code that has these criteria or these standards or factors or considerations? Could you please distribute them to the ZBA so we can review them and have them when we review these special use permit applications, whether it's for a bed and breakfast, doggy daycare, drive-through fast food restaurants, or typical special use permit. So look to your local law, look to your zoning code. That's where you'll find your criteria, and just follow them and make sure the applicant submits the required information, testimony, documentation, plans, and drawings to meet those standards in your special use permit criteria, again, in your local zoning law. And lastly, use variances. There's four, we got 10 minutes left. There's four criteria for an application for a use variance, all four of which must be met by an applicant. If an applicant, developer fails, that cannot meet any one of these four, it must be legally denied. You're obligated, statutorily mandated, to deny an application for use variance if any one of the four criteria are not satisfied. And one of them is the alleged hardship. We use the word hardship here. The alleged hardship has not been self-created. That's one of the criteria that has to be met. So the applicant developer has to provide proof that the alleged hardship has not been self-created. And I'm going to go out on a limb here. 99.9999999% of applications for use variances, the hardships are self-created. You don't need to go any further. So that, and the other three criteria, by the way, are not as hard, but they're pretty darn hard. They're pretty darn hard. And I'll give you another one. Let's see. The applicant cannot realize a reasonable return. That essentially means profit. So the applicant cannot realize a profit, provided that the lack of profit is substantial as demonstrated by competent financial evidence. So that criteria essentially saying is the applicant has to prove that she cannot make a profit using the property for any permissible use in that zoning district, any permissible use. And usually there's many more than one. When people think of, for example, you're in a single family zoning district, like, an R15 zoning district, single family zoning district, people will say, talk to your building inspector. Not only single family homes, there's lots of other stuff that's allowed in a single family zoning district. Houses of worship, for example. There are usually a bunch of special use permit uses. There are types of uses that are not uses permitted by right. So when you hear of it's a single family detached residence zoning district, it's an R15 or some type of R district, that usually means that single family detached residences are uses that are permitted by right, But there are lots of other permissible uses, I guarantee, that are special use permits or accessory uses, or there's usually a little smorgasbord of uses. But not only that, so the applicant has to prove to you that she cannot make a profit using the property, developing the property for any permissible use. A profit, $1, that's a profit. Usually a use variant applicant is coming before you for a use variance because they want to make a bigger profit. They want to make a bigger profit. So they're proposing a use that's not allowed because by having that use, they're going to be able to make a bigger profit. That's not what criteria number 1 says. What criteria 1 says, if you can make any kind of a profit, then your application for a use variance must be denied. Now, there's 2 other criteria that must be met. We don't need to go into them now. We don't have time to go into them now, but even if we did, we're not going to go into them, because if and when you ever get an application for a use variance, I assure you, if we spend 3 hours on use variances tonight, you're still going to need to be guided by your legal counsel, by your ZBA attorney, by your village or town engineer, village or town planner, your building inspector. And it is an excruciatingly detailed and difficult review. And it takes a few months if it's done properly, and it's subject to SECRA environmental review on top of everything else. So just be warned that if you see an application for use variance, pause the application, talk to your legal counsel, talk to your ZBA attorney, your building inspector, village planner, town planner, village planner, and say, hey, Dennis Michael said that a use variance application really should take a very long time if we're doing it right, and it's subject to environmental review under the State Environmental Quality Review Act. Have we done all that? Are we doing everything we're supposed to be doing? That's your obligation, all right? And then your professionals will guide you through a use variance application. I think we covered everything, right? Special use permit, interpretation, use variance, area variances, obviously. We touched upon SECRA and how they relate to your applications. We can't go into religious uses. That's a whole other session. I mean, we can go into it legally. I'm not saying the law does not allow us to. What I'm saying is that that's a whole other session, and I'm sure there will be sessions on religious uses. So I'm done. We have 5 or 6 minutes. I'll take whatever questions I can squeeze in.
All right, well, there's one person who, when you're talking about flood zones, I don't see a question, but they're pointing out that if you were on the river, you would have 2 FEMA flood zones, 1 areas where the danger was from rising waters, and 2 areas where the hazard involved wind-blown trash and rising water. I guess it's just worth mentioning that, you know, not all flood zones are the same.
For sure, they're not. There's the velocity. I think the
velocity zone,
right?
Velocity zone has running, moving water, and other flood zones just have rising water. Also,
Correct.
the regulations will be different whether if you're on an inland stream or creek versus the Hudson River, which is considered coastal.
But you don't need to, not you, Adam, you as a ZBA, you don't need to concern yourself with that. That's for professional consultants, village planner, town planner, engineer, so on. And again, the only reason I brought that up is I try very hard every year to come up with an example for an application for area variances that is not a self-created difficulty, because they all are. And the only one I can come up with is the Superstorm Sandy, where people that wanted to renovate their homes or rebuild them had to go higher now to comply with the new FEMA flood FEMA flood insurance regulations. And it was like, well, geez, if we did this a year ago, we would not need a height variance, so that to me, that's not a self-created difficulty. That's the only example.
In some ways, you're also eliminating one nonconformity if your house isn't conforming to the flood regulations. So,
right. Well, you don't have to raise your house. It's only if you're renovate, if you're doing some type of 50% or more of the floor area is being under construction, and whatever it is. I don't know. But anyway.
A good reason to grant a variance, I think. Does the village master plan impose any consideration on the ZBA?
No. The master plan is something that should be reflected in your zoning regulations. You are guided and must be guided and only be guided by your adopted zoning code, your regulations that are codified in your local zoning law. And also by New York State law. So New York State law mandates your criteria or considerations. The use variance, the 4 use variance criteria, all of which must be met, every single one. or the application must be denied. And the 5 area variance considerations, which must be weighed. It's a weighing process. Not all of them need to be met. That is your mandate. That is what you must follow. The master plan, comprehensive plan is really it's a guide for the community, for the legislative body, for the town board or village board, on what the village or town would like to see in its development of its community. It's not actually law. The master plan or comprehensive plan, if it's not codified into your town or village code, it's not law. It's just a guide. It could be helpful though. It could be helpful though with an interpretation application.
True.
Ask your ZBA attorney if you get a difficult interpretation application and you can't seem to find an answer in your zoning code for guidance. The next place to look really is your master comprehensive planning document, because that is a secondary source. Again, it's not law, it's a guide.
Okay. Another question, can a ZBA decline or refuse to entertain an application that has outstanding issues like code violations? Can
Definitely not.
ZBA,
I already know what it's going to do. You want to finish the sentence?
just can a ZBA set such a policy?
No, absolutely not, unless it's in your local law. So if your local law, it doesn't have to be this, it doesn't necessarily have to be the zoning code. It would be preferred if it was in your zoning code. But it has to be in your town or village code that says that if there are open zoning, building, or fire, property maintenance, et cetera, violations posted or noted against the property, then an application to a zoning board of appeals may be prohibited or denied or not processed. That would be the only way that you could do that. But I'm going to go on a record here of saying, I'm going to say something. Even if you do have that local law, in my legal opinion, that local law is unconstitutional. That is an unconstitutional local law. So number one, the only way you would be able to do that is if you have a local that says you can as a ZBA. And if you did have that local law, in my legal opinion, that local law is unconstitutional. You cannot prevent an applicant from petitioning a zoning board of appeals for relief from the strict adherence to the zoning regulations. That's what a ZBA is for. And not only that, there's a provision in New York State town law and village law that says that if a defendant in your local justice court who's defending zoning, building, or not fire code, you can't appeal. If there's a defendant in your local justice court that's defending a zoning code violation, and an appeal before the ZBA, if it's granted, would remedy that zoning code violation, that prosecution of that zoning code violation must be stayed. It must be stayed. The village or town prosecutor cannot prosecute that zoning code violation in your local justice court while that ZBA application is pending. So in fact, New York State village and town law actually has a provision in there that says the opposite, that almost suggests that an applicant has a right to appeal a zoning code violation to a ZBA while there's a zoning code violation pending. There's actually law, New York State law that addresses it indirectly. It's not explicit. It doesn't exactly explicitly say that a ZBA must allow an applicant to appeal an application, must be reviewed by a ZBA. A ZBA must allow that application to proceed if there are open zoning code violations. The statute doesn't say it explicitly, but indirectly it's implied in a provision that says if there is an appeal pending before a ZBA, the zoning code prosecution of those zoning code violations that relate to that ZBA appeal, that prosecution must be stayed. It must stop while that appeal is pending. So that, and for many other reasons, I think that local law that I think if there is a local law that says what what the inquirer is asking, that local law, in my legal opinion, would be unconstitutional. But I know we're over time. GML, you gotta comply to New York State General Municipal Law. Your attorney will guide you, or your building inspector, your clerk secretary will guide you. If it's subject to GML, you all probably know you need a super majority of the board. So if it's a 5-member ZBA, four of the five must vote in favor of an approval. If there's a GML that's disapproving. So if there's a GML that's a disapproval, 4 of you must vote to override that disapproval. And all of those comments that are in that disapproval, unless they are accepted by the applicant and imposed as conditions as a part of the approval, they don't have to be imposed by the ZBA, they're imposed by default. But if there are any of those comments that are part of that disapproval from the county planning department as part of that GML report, any of those comments that the applicant is requesting you to override, 4 of you must vote in favor of the override. So essentially you need 4 members of the ZBA to approve an application that there's a disapproval from the GMA, or if there's a GML that's recommending modifications that the applicant doesn't accept wholesale. So if you have recommended modifications from the county, the applicant must agree to all of those modifications, then you don't need a supermajority. So again, if there's a disapproval from the county planning department in the GML, if there's a disapproval, then you need 4 members, a supermajority, to vote to override the disapproval and to override any comments that the applicant will not agree to as part of a conditional approval. And if it's just a recommendation of modifications in the county GML report, if the applicant wants you to override any of those recommended modifications, you need a supermajority. You need 4 of 5 to vote to approve the application and to override those modifications that you want overridden. All the other modifications must be complied with as if they are conditions of the approval. Sorry for the going over a few minutes. I'll stick around for a couple more minutes if there's any other burning questions, Adam, or a question that you think is, with no offense to those questions that you don't.
Well, I'll just mention, Mr. Carmichael, I'm not sure exactly what your question was referring to, so I'm not sure how to, if I'm to answer that or to relay that. But there is a question. Is the ZBA attorney specifically for the chairman, or can they interact with other ZBA members separately?
The ZBA attorney is attorney to the board as a body. So, but just like the president of the United States or the chairman of any board, a corporate board in the business world, the chairman runs the meeting. The chairman sets the agenda. I know usually it's a building inspector or clerk secretary sets the agenda, but really, if you look at your local zoning code, most local zoning laws will say, establish the chairman or chairperson of the land use board to sets the agenda. The chairperson runs the meeting. The chairperson essentially says, runs the meeting. The chairperson runs the meeting. So the ZBA attorney does not counsel only the chairperson. No, he counsels the entire board. Can any singular member of the ZBA say, I would like to speak to our attorney alone? I would like to get a legal opinion. Just this one member wants to hear an opinion from the ZBA attorney alone. I think that ZBA member has that right. I think he has that right, just like any member. I don't think it's a good idea, but legally it's okay, it's appropriate. Same thing goes for the chairperson. If the chairperson wants to hear an opinion from the ZBA attorney privately, the chairperson can do that, just like any single ZBA member also has that right. So no, to answer your question, the ZBA attorney is not the attorney just for the chairperson. He is the attorney for the entire board, and each board member individually, as within the scope of their duties as a ZBA member.
Not there to do the closing on your code.
Yeah, exactly.
All right. Well, we're 9:07 and I don't see any new questions coming up, so we could probably wrap it up and call it a night. So first of all, thank you very much, Dennis, for doing this once again for the Federation. Anybody can look at a bit of regulation or statutes and know what the words mean, but knowing, or know what the words are, but knowing what the words mean is a different story. And then being able to take that meaning and put it into practical use and practice is yet another one. So I appreciate you sharing your expertise on how these arcane rules are, interpreted and enforced, and ultimately the mechanisms for doing so. I also want to thank everyone for joining us, and thank you for not just for tonight, but all the other nights you give up to volunteer for your community. Some of the questions that came through today, we saw that sometimes it's a thankless job, or even a job where you're occasionally yelled at and threatened. So thank you, if for whatever it's worth, for helping out and volunteering. Again, if you are on a board outside of Rockland County and want a certificate of attendance, or if you just have a question about this, I put my email in the chat. It should be there. So please just shoot me an email and I'll get that certificate to you or answer your questions. So that's all I have. So again, thank you very much. Thank you very much, Dennis. Thank you, everyone, and have a good night.
All right, thank you very much for having me. Bye-bye.
Thank you.